do our best. So we have paper and pens, and what we ask you to do is that if you have a question during the debate, please write it on a piece of paper, raise your hand, one of the Shurat Hadin staff will come and grab it from you, and like I said, we'll go through them, we'll do our best. Some will be similar and we'll be able to weed some out, we'll do our best. Not making any promises, but I'm gonna walk through. If anybody wants a piece of paper and a pen, just raise your hand, I'll bring it to you. Good evening, everyone, and welcome to Deceitful Coup or Overdue Reform, a gloves-off debate over Israel's judicial reform, sponsored by Shurat Hadin, the Israel Law Center. My name is Rachel Weiser. I'm a U.S. licensed trial lawyer, and I'm proud to be a senior attorney at Shurat Hadin and also the Chief Development Officer here. And I'll be your MC for the evening. First, thank you. First, just some very quick housekeeping. I don't know if that term is used anywhere but in the courtroom, but in the courtroom you say, first, a little bit of housekeeping. The program for tonight is going to start with Shurat Hadin's fearless leader, Nitzana Darshan-Leitner. She's going to speak to you very briefly about Shurat Hadin, what we do, why we're here. Then we're going to move into our debate, which of course will be the primary portion of the evening. And then we are going to try, as I mentioned before, to have a short Q&A. Again, I can't make promises. I want to make it very clear. I've been standing in this place before when people got very upset that we weren't able to do questions and answers. So just letting you know now, we're going to do our best. I'm taking the questions and answers, the questions. If you have one during the debate, just raise your hand. One of the Shurat Hadin staff will come and take it from you. We'll go through them and we'll do our best to pick at least a few sample questions that represent at least the majority of the questions that we're seeing. Also, I suggest you write legibly. And if you make your questions shorter, we're more likely to ask them. Okay, so let's begin. Please allow me to introduce Shurat Hadin's fearless leader, Nitzana Darshan-Leitner. Nitzana has been leading the legal fight to defend Israel in the courts worldwide since the time of the Second Intifada. In fact, Shurat Hadin this year is celebrating its 20th anniversary. As the president of Shurat Hadin Israel Law Center, she has represented hundreds of terror victims in legal actions against terror organizations and their supporters. She has won billions of dollars in judgments and collected hundreds of millions of dollars that went directly to the victims of terror. Most importantly, she gives terror victims a voice, the ability to fight back, and at least in part to heal, physically and emotionally. Collaborating with law and security experts from all around the world, Shurat Hadin utilizes court systems to go on the legal offensive against Israel's enemies, defending against lawfare suits, fighting academic and economic boycotts, and challenging those who seek to delegitimize the Jewish state. Nitzana is the co-author of the national bestseller Harpoon, which recounts Shurat Hadin's work with the Israeli Mossad to wage financial warfare against Israel's terrorist enemies. In 2023, Nitzana was chosen for the 5th time as one of the 50 most influential Jews in the world by the Jerusalem Post, and as one of the 50 most influential Israeli women by Forbes Israel. She has a law degree from Bar-Ilan University and an MBA from Manchester University. And probably most impressive of all, Nitzana is the mother of 6, including a set of triplets. That always gets the biggest ooh and ah. The woman goes to court against terrorists, but triplets is always the most exciting. Please welcome Nitzana Darshan-Leitner.
Good evening, Moadim Lesimcha, Chag Sameach. It's such a pleasure to have you all to make through traffic to get to Jerusalem in time. Just want to tell you about Shurat Hadin a little bit to the ones that still don't know. And then we'll dive into the fascinating debate, something that every time I go and speak about Shurat Hadin abroad, the first question I'm asked is, what's going on in Israel? So before we're going into what's going on in Israel, let's talk and speak a little bit about the accomplishments of Shurat Hadin in the past 20 years. We actually started in the beginning of the Intifada, the second Intifada, year of 2000. Suicide bombing, drive-by shooting, ambushes, knife attacks, people getting killed on a daily basis on the street of Jerusalem, of Tel Aviv, of Hadera. And we finished law school. I was a law student at Bar Ilan University. My friends were in Tel Aviv, Jerusalem. And we decided to do something that never was done before, to fight terror organizations in court. We realized that money is the oxygen to terrorism, and if we can block their funds, perhaps we can block the terrorism. So we just fearlessly went and filed lawsuits against Hamas, Islamic Jihad, Palestinian Authority in Israel and the United States. People thought it was unbelievable, it was insane, what were we doing exactly? But after 2 years, we started winning in court. We won judgments for hundreds of millions of dollars. We received liens on Palestinian Authority money. We got unprecedented decisions that we were approached by the legendary head of the Mossad at the time, Meir Dagan, who headed a secret unit in the Mossad called Harpoon. It was a secret unit until we wrote a book about it. And the unit's target was to follow terror money, to target the money, to kill the money. That's all they did. And they told us that during their operation, they accumulated so many evidences and so many documents. Perhaps we can use this information in our legal proceedings. If we can expand our activities and file more lawsuits against the Palestinian Authority and against those who actually wired the money from Syria, from the United States, from Jordan into the hands of the Palestinian terror organizations in Judea and Samaria and Gaza, the banks. We agreed, but we couldn't do it as private lawyers anymore, and we established Shurat Hadin Israel Law Center, a non-for-profit organization to take these hundreds of cases and file it in an orderly manner in the courts around the world. We became those who defend Israel in the courts globally, fighting Israel's enemies. We do it with collaboration with former intelligence officers and sometimes with current ones. We're able to block the funding. We're able to file lawsuits against Iran, Syria, North Korea, Palestinian Authority, Fatah, Hamas, Hezbollah, against Iranian banks, American banks, Lebanese banks, European banks, Arab banks, and we're able to get judgments against them and collect them. In the course of operation, we're able to change the banking system in a way that no bank agreed anymore to open bank account to a designated organization. No bank agreed to operate in terror zones like South Lebanon, like Gaza. We received billions of dollars in judgments and collected hundreds of millions of dollars given to the hands of the terror victims. We put liens on Iranian assets, on Syrian assets, on Palestinian Authority's assets. And as a result of our cases, we are told by the security services that money diverted to terrorism reduced in 60% in the harsh days of the Second Intifada. But then, in 2015, there was another type of intifada, the knife intifada, or as Prime Minister Netanyahu called it, the Facebook intifada. young Palestinians were grabbing knives and going and kill Jews. And very quickly, the security services realized that these young Palestinians are incited to go and kill on the social media. We immediately filed lawsuits against Facebook, against Twitter, against Google for aiding and abetting terrorism. Our cases were litigated for 8 years, and all the time were dismissed by the court for immunity defense that the social media companies alleged. Section 230 of the Communication Decency Act, a law from 1996 that Congress legislated to keep the internet open, grants blanket immunity to the social media services. Our cases were dismissed until last year, when we reached, for the first time, the Supreme Court of the United States in the case of Gonzalez versus Google. Naomi Gonzalez, was a 24-year-old student when she went and received a scholarship to learn a semester abroad in Paris. She was sitting in a cafe where ISIS carried out this horrific terror attack in the Metal Death concert. They killed 130 people. She was the only American that was killed. We filed a lawsuit against Google because Google, that owns YouTube, allowed ISIS to screen all their beheading videos that incited people, encouraged them, recruited them to go and join ISIS. And for the first time, the Supreme Court of the United States agreed to hear the case, and in a decision that was handed down in June this year, the court ran down the case to the lower court, allowing us to prove the case in terms of liability, and did not agree to dismiss it simply for the immunity defense. When our enemies realized that they cannot beat us militarily, they started using non-conventional weapons, but very devastating one called lawfare. And they reached the International Criminal Court, blaming Israel for committing war crimes against Palestinians, and the court with no authority, even though Israel is not a member in the Rome Treaty in the court, and even though the Palestinian Authority is not a state, agreed to open investigation against Israel in the court. Shurat Hadin has been fighting there since 2015, filing lawsuits against Hamas, against Islamic Jihad, against the Palestinian Authority, doing it on behalf of victims. One of them is Alel Yafa Hariel, 13 years old, beautiful girl that was stabbed to death in her bed 17 times by a Palestinian terrorist that came to her house. And we fight the Human Rights Commission of the UN, the most anti-Semitic body in the world. Benji, you see yourself there? Good. This is the committee that every time there is an operation in Israel, opens investigation for war crimes allegations. This time we say that we are going to demonstrate in front of the UN Human Rights Commission in Geneva, dressed up as terrorists, blessing and thanking the committee for helping Hamas to destroy Israel. We also filed a lawsuit against the UN Human Rights Commission, which is pending now in the District Court of Jerusalem, for publishing the blacklist and fighting BDS. Airbnb, when they wanted to boycott Israel, to delist houses from Judea and Samaria from their website, we went and filed a lawsuit against them in the court in Delaware for breaching, violating the fair housing law. Airbnb came to us after 3 months and asked to settle the case out of court and backtrack their policy of boycotting Israel. Ben & Jerry's, when they wanted to boycott Judea and Samaria and announced that they have no intention to continue and manufacture and sell ice cream in this area, we went and threatened to grab their trademark in this place and open a company called Ben & Jerry's Judea and Samaria. We did it because, according to the American law, once you announce you have no intention to work in a certain area, you lose your right for the trademark in this territory. It was free. We were the first to grab it. We also sent them a letter signed by 1,000 Israeli students telling them that based on the research we conducted, we found out that their offices and factories in Vermont are on occupied territories that was taken away by from the Abenaki tribe. We wrote to them that we know that they are very concerned about occupying territories, and we suggested that they vacate their factories and offices in Vermont. We told them that justice and moral begin at home. And the Gaza flotilla, every year, at least until 2018, the organizer of the flotilla were trying to breach a sea blockade over Gaza. We threatened the insurance companies, threatened the satellite communication services companies, and slowly brought to cancellation of the flotilla until 2018, until the last time they came, where we actually went and put a lien on their boats, grabbed the boats, and we actually became the owners of their boats. And of course, we have to train the next generation. So we're doing it by lawyer seminar. We had 250 lawyers so far. We're doing internship program with hundreds of students. And we run our ultimate Mossad missions. 2,500 people so far came and learned about the security situation in Israel and how Shurat Hadin is fighting back. We represent a lot of victims in hundreds of proceedings in Israel, United States, Canada, and Europe. We represent thousands of victims, sometimes tens of thousands of them in a lawsuit against Facebook, 50,000 in a lawsuit in the International Court, and just kept growing and growing. And I would like to speak to you about a project that it's not the bread and butter of Shurat Hadin, but we felt compelled to do it. Usually Shurat Hadin stops terrorism or fight terrorism after it happens. This time we try to block it before. And we do it due to the escalating number of terror attacks in the roads of Judea and Samaria. We realize that drivers can act and can block or can stop or can survive a terror attack if they know how to do it. We saw that David Stern, for instance, a former Marines guy, was shot by a terrorist when he was driving in the road of Hawara, but was able to pull his gun and shoot back. On the contrary, we saw that the three members of the D family, the mother and the two sisters, when they drove the car and got shot by a terrorist, they lost control over the car. They crashed into a tree, which allowed the terrorists to come and shoot bullets from zero distance into the car and kill them. We took upon ourselves to organize driving courses in Judea and Samaria to learn people how to survive a terror attack.
Did you know that most terror attacks are stopped by civilians? Israelis have been facing a terrifying escalation of deadly terror attacks on our roads. This has been the bloodiest year in 2 decades. While Shurat Hadin is working to assist these families in legal action seeking justice, we are compelled to take proactive life-saving action as well. Shurat Hadin has launched a widespread training initiative to teach Israelis how to survive terrorist violence on the roads, and the response has been overwhelming. The driver survival course brings top security experts and medics to teach civilians how to respond. It provides defensive strategies, emergency tactics, simulation drills, and life-saving first aid instruction. Every Rosh Hashanah, we pray to be written in the book of life. This holiday season, help add names to the book, one driver at a time. Wishing you and yours a very happy, healthy, and safe New Year.
Remember the names, because today we are representing the new wave of terrorism in courts. This is what we do. We'll continue fighting terrorism in court. We do what the government cannot do. The government cannot file lawsuits against the organizations. Only a private organization, private lawyers, private people can handle this fight. We will do it. It's going to be a hard battle. It's going to be a very big fight. But in the end, I promise you that we are going to win. Thank you very much.
Thank you, Nitzana. Okay, so now we're going to start our debate. The issues surrounding the judicial reform have been weighing on all of us for many months now. And to be honest with you, I was sort of opposed to the idea of Shurat Hadin jumping into this because I felt like it was a difficult topic, and generally at Shurat Hadin, we don't see ourselves as left or right. Everybody should be against terrorism. However, recently the issues have sort of touched on the work that we do. Many of you may have heard of some discussion about whether or not Israel's judiciary could affect actions brought against Israeli soldiers in the ICC, which, as you saw from Nitzana's presentation, is something very, very directly relevant to our work. And we were inspired to get involved in a way that we could try to help shed some light on the real issues and hopefully maybe find some real solutions. We wanted to provide a clear understanding of the proposed judicial reform in Israel, the conflict surrounding the reform, and address the concerns that have arisen. We wanted to do this based on the law and from the perspective of actual legal experts. So we invited our distinguished panelists representing diverse perspectives to engage in an intellectual and respectful discourse on this critical subject. It is an honor for me to introduce our two panelists. I will say an introduction and then I will invite them up to the stage. First, I am honored to introduce Advocate Oriel Lin. Advocate Lin holds a Master's of Law degree from Hebrew University and from Berkeley. Today, he serves as the president of the Tel Aviv and Central Israel Chamber of Commerce, as well as the president of the Union of Chambers of Commerce in Israel. Advocate Lin began his career in litigation, then proceeded to corporate management, and in 1973, he joined the National Liberal Party. Advocate Lin was elected to the Israeli Knesset in both 1984 and 1988. He has held several positions within the Israeli government, including Governor of State Revenues and Director General of the Ministry of Energy. In 1988, he served as the chairman of the Constitution, Law, and Justice Committee. In this role, Advocate Lin led significant reforms in the Israeli political system, including passing the Basic Laws, significant to the development of Israel's legal framework. Today, we are honored to have Advocate Lin join us to share his invaluable insight into these transformative legislative changes and their impact. In the debate, he will be taking the position against the reform. Advocate Lin, please join me on stage. Our second esteemed debater is Professor Avi Bell. Avi Bell is a law professor both at Bar-Ilan University and the University of San Diego. He has also served as a visiting fellow at Harvard Law School, a visiting professor at the law schools of Fordham University and the University of Connecticut, and as director of the Global Law Forum at the Jerusalem Center for Public Affairs. Professor Bell recently completed his term as president of the Israel Law and Economics Association. Today, Professor Bell serves as a senior fellow at the Kohelet Policy Forum and as Dean of Law, Governance, and the Foundations of Democracy, an international perspective program hosted by Israel Law and Liberty Forum. Professor Bell received his BA and JD with honors from the University of Chicago and his doctorate from Harvard University. Prior to entering academia, Professor Bell clerked for Justice Michael Chesson of the Supreme Court of Israel and for the Administrative Law Department of Israel's state attorneys. He worked as an attorney for an Israeli commission on the legal rights of persons with disabilities alongside the Ministry of Labor. He also worked for the Boston law firm of Foley Hoag and the New York firm of Wachtell, Lipton, Rosen, and Katz. Professor Avi Bell is among the world's leading scholars of property and intellectual property, international law, administrative and constitutional law, and the economic analysis of law. He has published influential articles in each of these areas, as well as constitutional law and legal philosophy, in top legal journals such as the Yale Law Journal, Stanford Law Review, and Columbia Law Review. His scholarship has been recognized with numerous awards. In 2021, Professor Bell was named one of the top 100 people positively influencing Jewish life by Allgemeiner newspaper. Professor Bell's research and insights have left an important mark on the legal world. Today, he shares his expertise with us and will be taking the position in support of the reform. Please welcome Professor Avi Bell. And I would like to invite back to the stage our esteemed moderator, Nitzana Darshan-Leitner.
So in the past year, Israel have been torn apart. Israeli society have divided over what some called a judicial reform and some called a deceptive coup. It began when the government announced that they are going to pass a judicial reform because Israel was taken over by the judiciary. It has too much power, it has to be restrained. Israel was taken over by the Supreme Court, by the legal advisors, by the Justice Ministry, by the judiciary. And this is not a democracy, this is actually a dictatorship. You can't have balances and checks if all the power is in the hands of the court. It's time to make Israel a democracy again. Hundreds of thousands of people went out to the streets, wanted to block this reform with their own body. They said the politicians will have all the power and they will not be able to be restrained. If they take away the power from the court, if they weaken the court, who will take care of the rights of the minorities? Israel will become a dictatorship. There will be no checks and balances. It has to stop. Now, tonight, we'll try to sort out this type of debate, this question. Is this an overdue reform that Israel is needing for many, many years, or it's actually a coup d'etat that this current government is trying to hold? And I'm very honored to have two distinguished scholars next to me. Advocate Uriel Lin, who was the head of the Law and Justice Committee when the basic laws were legislated, and we'll dive into it later on. and Professor Avik Bell from Kohelet. And I would like to start actually with you, Professor Bell, because Kohelet is the one to be blamed for this whole fiasco where we are here. Kohelet proposed a judicial reform, and the government gladly adopted it. And I wanted to ask you, what is this judicial reform and why we need it? I mean, all these 75 years that the State of Israel is existing, what happened suddenly that there is a need for a judicial change?
First of all, thank you for having me here. And I do have to say one thing. Kohelet, I'm proud to say, was founded about 10 years ago. I've been a member since it was first founded. I've been working on judicial reform a lot longer than that. There were judicial reform efforts in 1999. I worked also with Daniel Friedman, who was working on this in the mid-2000s. The need for judicial reform has been around a long time because the problem has been with us for a long time. And the basic problem is that Israel's legal system, its system of governance, changed dramatically during the period of Aaron Barak's service on the court, first as justice, then as chief justice, then as president of the court, throughout the 80s, 90s, early 2000s. And he revolutionized everything about the way the court dealt with the law, with governance, and he therefore revolutionized Israel's constitutional structure. The court took for itself primacy in policymaking. It opened its doors up to all issues. There is no longer a category of issues that was not justiciable. Every issue, every policy issue gets to the court. The court decides on everything. It is designed that way in the post-Barak era. And the court's frank about the fact that it doesn't do so purely by law. In fact, not primarily by law at all. Manny Mautner criticized this approach 40 years ago, saying that the court had moved from a system of what he called formalism to values. That is, from a rule of law, ruling according to formal rules, over to a system of governing according to ideological and moral values. Now, that's fine for elected officials to do in a democratic society. It's problematic when the last word belongs to, on value questions, belongs to unelected people who are, at this point, no longer even respecting the law. They view themselves as above the law. And in a system in which they no longer recognize any limits on their power whatsoever, we're right now seeing the court dealing with several cases having to do with their own authority, where they've already announced in the hearings that they're not dealing with any text of any law that tells them what they may and may not do. Rather, what they're saying is they're deciding whether the parliament will be permitted to enact laws that define the powers of the court, whether there are other things the court can pull out of the ether, can pull out of its value structure. This is a system that's fundamentally unhealthy. It's no longer purely democratic. It makes the courts political. It removes limits from the courts, giving the courts absolute power, which is inherently corrupting. And it takes away any possibility of reason to compromise. It makes all issues absolute, where one goes to plead one's case before a group of aristocrats, and they issue their judgments.
So, Advocate Lynn, it looks like we need a reform. If the court is taking over and it makes himself the legislator because he has the ability to cancel laws, he makes himself the government, he steps into the shoes of the government and puts his discretion instead of them. Perhaps there is a need for a change.
Well, let's put it this way. A certain modification is right. But sometimes it's not only the content that counts, it's also the way it's being presented to the public and the way that the people who want to do it declare how they want to do it. So let's start with that. The judicial reform presented today by the Minister of Justice, Levin, was announced like it was a war, like he's launching a war against a great part of the population in Israel. Now I can tell you, I myself, in my previous position as the chairman of the Constitution, Justice and Law Committee, I passed many laws, 95 of them. Some of them were the most important in changing the political system, including direct election of the prime minister. There was no fight between the parties. It was not a war. All the political parties were participating. Now, when you launch a change, a major change in your judicial system, that we know that affects very, very significantly whatever the way that this country is going to be conducted, you don't do it by declaring war. You have to do it in a wise way. So I'm saying that because now the question really is not anymore the content. The starting of this judicial reform started in a way that created a split in the population. And this was very, very bad to start with. Now, as to the content, I would say yes, there need some modifications. I even myself presented some modifications. I'll give an example. In Israel, we don't have one document constitution, but we have a decision from 1950, the Harari decision, that says or spells out that the Israeli constitution will be done over years of time in the future, basic law after basic law. And when we finish all the basic laws, we put it together, and that's going to be the Israeli constitution. Usually constitutions are in the form of one document constitution. But this is not the case in Israel. So today, for example, when you need to put a reform, one of the first things you should do is end the Israeli constitution. What does it mean? It means that you have to take all the basic law passed, decide which one of them is not really a part of the Constitution, but only a solution for a certain coalition problem or a certain personal problem. That not be a part of the Constitution. Decide on the right basic law that are really intrinsic part of the Constitution, and then pass the special law legislation, which gives a certain supremacy on equal protection to all the basic laws. This is one, for example, the step that we have to do. We have to concentrate on that. We have to do it right. And this is the way to start with a change in our judicial system.
In the current situation, where Israel does not have a constitution, and it most likely will not have a constitution, because for many, many years, since the beginning of the state, there were a lot of trials having a constitution. Unfortunately or fortunately, there is no agreement between the parties. So when the current situation is lack of constitution, those who advocate for the reform claim that the Supreme Court cannot be above the Constitution, meaning he cannot cancel basic laws, he cannot even cancel laws. What do you answer for this?
Listen, a basic law is not a basic law by title. You can take every regular law and I put a title Basic Law in order to give it a special protection from judicial review. And it was done, and done many times. So I cannot really tell you that Israel does not have a constitution. Still, Israel is on their way of making a constitution according to the Harari decision. However, the Knesset in many cases spoiled this work by inserting into basic law that are not a real part of a constitution, by giving a title, basic law. So I say that today the question, if the Supreme Court has the power, the authority to repeal a basic law, it's not a question of formality. We have to go by the content of that law and decide if it's really a basic law or not. And then if it's a basic law, no, they should not touch it. But if, for example, and I'm giving this example so we understand why we need the judicial review in Israel, why we need it very badly in order to protect basic values. What do you think about a country that will appoint a minister, a person who committed bribery while he was a minister? It's done in Israel because we don't have basic values. And then later on, after being a minister, same person is being convicted of corruption by a plea bargain, and again the government wants to appoint him as a minister. This shows you that we don't really have regard for values, and this is why we need badly the judicial reform in Israel. I'm sorry.
So
We need badly the judicial review of the Supreme Court.
So, Professor Bell, this makes some sense. If there is no judicial review on the acts of the government, they can, appoint anybody they want, corrupt as much as can be. And let me add, if there is no judicial review for human rights violations, we might turn to, to halakhic states. Women rights would be violated, LGBT rights, Arab rights, minority rights, with no review of the court.
It is an essential question, I think, in every government, in every system, every society, how it is that we protect our basic liberties, how we protect human rights. And there's different methods that are used around the world. I think that ultimately the two most important guarantees, the ones that maybe seem the most obvious, but people don't much pay attention to them. As John Adams said, it's not possible to have a free society without a freedom-loving people. A society that is not committed to its liberties will not be free. And as Jefferson said in a variety of ways, ultimately, if you cannot change your rulers, you cannot ensure that you have rulers that regard your liberties. Those are the two most important things. Now then you have all these structural things we can try to do to try to ensure that if we are indeed a liberty-loving people, which I believe we are, and if we stay a democracy, which I'm less sure we're going to be able to if the court continues to seize powers, then you have mechanisms like enumerated powers, limited government, federalism, separation of powers, checks and balances, all these various things that all also have to be accompanied by rule of law in order to make sure that there's respect for liberties. Now, there is no place in the world that's tried to do what the Supreme Court in Israel has tried to do, which is to promise to guarantee liberties, not through a rule of law, not through constitutional structures, but by the creation of a judicial aristocracy of unlimited powers that promises that it's benign and will protect our liberties. The problem is it just doesn't, right? It's not that this Supreme Court hates liberty and the rest of the society doesn't, loves liberty. The problem is that the courts, like every other institution, are institutions with vast powers. They're open to corruption. They have ideological tendencies of their own. And so if they've been good on some issues, they've been bad on others. You worry about how will defendants have their rights protected in court. Well, the Israeli Supreme Court, the Israeli court system has gotten rid of the exclusionary rule. You can be convicted on the basis of illegally obtained evidence in Israel. It's unbelievable infringement upon liberty, but this one comes from the courts. You have, just in the last week, you have the city of Tel Aviv decided to pull a permit for public prayer unless the group of Orthodox Jews agreed to drop the barrier that they had to.
I think that's not a matter of our judicial system. It's only an act of your people, and I don't think this should be really a shade on this matter.
If I may, to not interrupt you, but
we can argue about the question if it's right to make a decision that should not be a partition in the open space, the public space, between female and male.
You'll be able to answer.
I'm going to ask you not to interrupt as well.
The moment you finish, I'll let you answer.
The city pulled the permit unless their prayer practices would change. In the United States, this would be clearly unconstitutional. It would be an infringement of the freedom of liberty of the worshipers. It would be an infringement of their freedom of assembly. It got to the courts. The courts rubber-stamped this. The court said not just that it was okay, they threw in side comments along the lines of maybe it's a problem to have any gender-separated prayer at all for the Orthodox. Now, this is unthinkable. It's an unthinkable infringement of liberties. The court is not out there protecting the liberties, it's infringing them. Now, it's not that the court tramples liberties in all cases. It's simply that it reflects its own view. The problem when you have a system like this, where there is nothing above the court, and the court again has said, there is no constitution in this country. This is the only country in the world where the court purports to overturn laws of a democratically elected legislature without a written constitution. This happens nowhere else in the world. Right? The court accepts no limits. It doesn't accept it. It changes the rules on what is a constitution every few years. It's plain Calvin ball. Now, what can you do in a situation like this when it tramples rights? And the answer is there's nothing to do. That's the difference between a democracy and what we have. If we get back to a democracy, we can take these debates out of the courts where they're responsive to no one and bring them back to the public square. We won't always agree, but we will reach agreements that are functioning.
So, Advocate Lin, the problem seems to be that the court puts its discretion, its opinion, instead of the authority, something that he's doing without no authorization, and also cancel laws which looks like, again, with no authorization.
Well, let's put it this way. Judicial review.
And please, if there is an authorization, if you can indicate what it is.
Judicial review is a tool which is used in any legal system all over the world. The question is, what will be the scope of it? What should be how much far the court should go? Now, the court does not pass decisions according only to their point of view. They express a certain values accepted today, I believe, by most of the population. Because there are some basic values, some principles that should be the infrastructure on which the democracy operates. Now, judicial review is important because this is one of the most important functions of the courts. Because you must have the court to protect the people. If you will not have the court to protect the people, we must rely totally on the discretion of the executive and the government. And believe me, This is not a very good situation. Even if they are democratically elected, still, sorry, I don't know what you want to say with your hand, but you're raising the hand as if in
We're going to
reaction,
take...
as if in reaction what I'm saying. I know, but I want to know that when you raise your hand, you support me. So I will be relieved. Okay. There are two main areas of judicial review, and we have to understand it. One is judicial review in relations to legislation, and the other is judicial review in relation to the acts of the executive. You needed to be in both cases, in both categories. Now, judicial review in relation to legislation is being implemented much more over the world than in Israel. Because the law that we passed, what's considered to be the Israeli Bill of Rights, which is really a mini Bill of Rights, the law for human dignity and freedom, the law for freedom of occupation, those are today our mini Bill of Rights. If the court will not protect the basic rights of few people, who will protect it? Do you think that the parliament will protect it? The parliament will pass any law that they believe is right, and you'll have no protection. So all over the world, we accept the principle that must be the protection of the judiciary. And it's done in the United States, and it's done in all other countries, and they even have a special court of constitution which repeal many regular laws. So in Israel, after we passed this, what I call our mini Bill of Rights, the Supreme Court repealed only 22 cases. And yes, sometimes there is a clash between basic human values to what we consider may be the interest of the state. Yes, it could be a clash. And sometimes we may not agree with the decision of the court. And as a matter of fact, I offered a certain solution to this matter. Maybe we'll touch on it, but this is necessary. Now look the other category, decisions or the making of ministers. I'm not talking right now only the government, because the last amendment also relates to decisions of every minister. Now imagine that a minister can do exactly what he wants to do without any restriction, only because of his discretion and his belief. And believe me, they do have a certain beliefs, and every minister thinks that he's really right in what he's doing, and sometimes there may be other interests. We cannot really be subject to discretion or arbitrary discretion of the executive. I know they are elected, but being elected by the people, it doesn't mean that they have the power to do whatever they want to do. This is a very wrong idea. When people start telling me, hey, they were elected democratically, yes, right, so what? It means that they have the power to do what they want to do? We must have a protection. The only effective protection is coming from the courts. There's no other protection. So don't delude yourself to believe that there is here a problem of the court being too strong. Yes, he's strong. Now, why? Because you cannot simply refer to other country. You have to look at the political system existing in a certain country. And then you have to think if this principle is right or not. Now, I gave you just a short while ago an example how corrupt we can be. Appointing a minister who committed bribery while being a minister, again to be a minister, what do you think a kind of impact this will have on the young generation? You have to understand that the political system, the way they work, it's not really a vacuum. We have a young generation here, we educate him, we influence him. So this is why I'm saying we must have the judicial review on both categories, legislation and also executive actions.
I see that you want to answer, so please answer.
You know, there's no human society, there's no system of government, there's no institution that is possible that is perfect. I have many friends who are judges, I have many friends who are ministers, friends, members of parliament. Some of them are good people, some of them are not. Some of them are driven primarily by their ambitions and their egos. Some of them are good and honorable people. There's no guarantee of any institution that it will always function well, certainly not if you hand it absolute power. Now, there is only one institution in this country now that has unlimited power, and that's the court. And that's the court because it makes up its own rules. It's in fact, right now, engaged in several cases where it is pronouncing judgment on whether the law that has been duly enacted by the parliament will restrict it. And it is saying it is not bound by any law. It is bound by the values that it pulls out of the air. Now, sometimes these values are sensible, and sometimes they're not. You say that it's not possible to have a system without assistance of judicial review. The truth is, it is possible. It's not simply that there are countries without a written constitution where there is no judicial review of legislation, such as the UK and New Zealand. It's not only that. It's that there is absolutely no place in the world where the courts have liberated themselves from the rule of law and are simply free-floating appliers of rules that they make up on their own. Nowhere except for here. That doesn't make me feel comfortable. That makes me feel very, very uncomfortable. If I'm concerned about the absolute power of gentlemen like you in the Knesset, then I'm just as uncomfortable about the absolute power of other gentlemen, and I won't mention names, who sit on the court, who I also respect and acknowledge, but I simply don't agree with them. I won't agree with them on everything at any time. And it doesn't make sense that they get to decide that, it's time now, because by our infinite wisdom, we think welfare benefits for this person should be raised even though they have a car, and for that person should be lowered because they study in yeshiva. This radio station should be shut down because Sheva should be shut down. It may be that they're licensed to broadcast by the Knesset, but there may come a time at the end of time when there are no more radio frequencies left in Israel, and then a competitor may want this frequency, and so we, the court, have to shut it down. Now, what are you supposed to do when they make crazy decisions like this? And the answer is there is nothing to do. That's the problem with putting all your eggs in the basket of an unelected court that doesn't obey the law, that makes up its decisions ideologically by values, even if you agree with those values, right, is that you're putting yourself at the mercy of the ego and the ambition of people. And they are people. They're people on the courts, they're people in the Knesset, they're people in the government. And just by the way, when you say it's impossible anywhere in Israel for there to be somebody appointed who accepted bribery, I don't know if you've ever heard of the case of Marion Barry. But Marion Barry was mayor of Washington, D.C. He got caught on tape buying cocaine from an agent. He was arrested, he was tried, he was convicted, he served in jail, he ran again, and was reelected mayor of Washington, D.C. Now, why was he reelected? He was reelected because he convinced his constituents that law enforcement had misbehaved, that he was being singled out, that he was being badly treated. Now, there is a vast section of this country, I think a majority of this country, that no longer trusts law enforcement, that believe, as a matter of fact, it's not simply a majority. By the polls, we're getting to numbers on the order of 90% that don't trust law enforcement in this country. And if you want to know what is it that's going to lead, the most likely thing to lead to election of corrupt leaders, I will say it is abuse of power by law enforcement more than anything else.
So perhaps, I'll let you answer in a moment. So perhaps, Professor Bell, the way the reform was presented, or the way the government tried to pass this reform, was the one that brought out all the messes to the street. Advocate Lin called it a declaration of war. I can add and say that along with this reform, there were some laws that made people very, very angry, like what Advocate Lin says, appointing Derry again and again as a minister despite all his previous convictions, or the absence law of the prime minister that put Netanyahu now for good to stay, or other laws that prohibits wearing not-sneeze dress in the kotel and imposing half a year of imprisonment for whoever is doing it. Perhaps that scared the people. Perhaps there was a mistake by the way the government passed this reform.
I think it was Bismarck that said you have to look at lawmaking like sausage making. Right? The product may be very tasty, but don't look too closely at how it's made. It's a fact that political processes at any time are difficult, and people say populist and demagogic and awful things. They're not always entirely sincere. And Uriel, excuse me for this, when Uriel was defending basic law, human dignity, and freedom in the Knesset, he assured the plenum that the way it was now written, it was not possible for the courts to exercise judicial review on the basis of that law, which is a position he didn't stick to after it actually passed. Today, the court claims the right to exercise judicial review on the basis of the law. And this is part of political rhetoric. Political rhetoric is based on exaggeration. I think that where political rhetoric has gone off the rails in the debate over judicial reform is not in the timing of announcements, or the strength of announcements, or other proposed laws that were proposed or going to be proposed or not going to be proposed and gone nowhere, and good that they've gone nowhere. It has more to do with the scorched earth campaign that's been waged against it. I have to say, shamefully in a lot of cases. You have groups that are against the reform going out trying to convince companies and individuals around the world to boycott Israel, to divest from Israel. This is unthinkable. You have opponents of the reform going to serving soldiers in the reserves and telling them, don't show up, disobey your orders. This is just unthinkable. You have maybe the leader or one of the leaders of the reform, Shikma Breslev, labeling everybody who is on the pro-reform side a Nazi. We have people, Nehemiah Dagan, he's a Tataluf, a general who was head of education in the army. He put out a posting on Facebook. He said, it's great that you're out there protesting, but we have to go further. This is not the end of it. We have to go further, and we have to liquidate, not in the military sense, but we have to liquidate all the pro-reform people, except for those people from Kohelet. Those people you have to liquidate in the military sense. Okay, that is, we have to be killed. Now, what part of legitimate debate does that serve? Right? How can you carry on a constructive discussion when those who are your ideological opponents, it's not that they're sitting on stage and politely discussing and sometimes interrupting, which is the Israeli thing to do, but they're saying that I have to be murdered. Are we going to be able to conduct a debate, or do you think that that's it's the equivalent of the justice minister raising his voice in a press conference. There's something that's gone very, very wrong in the debate about judicial reform. It's not in the way it was proposed. It's in the way it's being opposed.
What do you think about that? Do you think that really the protesters are protesting against the reform or actually against the elected governments?
Well, first of all, I want to refer to a remark of Professor Bell that he said that in Israel, the only institute that has the final word is the court. Well, that's the way it is. This is in every country that we know very well, we are subject to the rule of the law. And the final decisions are made in any country by the courts. So there's nothing new about that. I'm saying this is a very basic, that's the foundation of any country, democracy that believe in the rule of law. Now, I know we may not sometimes like decisions of the court, but sometimes we may do like them, but this is not the question. The point is that the courts are really were trusted, and the essence of their function is not only to judge on civil cases or criminal cases. One of the main functions of the courts is also to protect all the population, all the civil people, from decisions of the government and decisions also of the executive. This is one of the main functions, and this is everything that relates to separation of power, the branches of the government, checks and balances, is because this is what we are talking about. That this is a very important function. Now, I can understand, and I was following the certain frustration of the present politicians who formed today the coalition, that they thought that the law in Israel is too powerful. And it passed decisions that sometimes against the interest, what they believe to be the interest of this country. I understand that. And as a matter of fact, I even proposed a solution to that situation, mostly in relation to the repealing of regular laws. Because I said, usually, when you really create or you define the basic rights, I'm talking right now, the basic rights of every person, what we call really the Bill of Rights, the basic rights, definitely you must have a protection on the population if the basic rights are being infringed by the parliament. Because this is the essence of this protection. It must be protected. But I want to tell you, really an understanding may be somewhat better. The whole judicial reform which it is presented today. In Israel, we know very well that the Knesset is controlled by the government. The government can pass everything they want in our parliament. It's not like other countries that have maybe two houses. We have one house, we have a coalition government, it's controlled by the government. The Knesset, the parliament, is controlled by the government. That's a fact. We may not argue sometimes, there is a certain deviation here and there, but in essence, it's controlled by the government. The government, to a great extent, is controlled by the prime minister. Irresponsible member of Knesset canceled the law which I once passed, direct election of the prime minister, and they canceled that law. They also canceled the clause that limited the terms of the prime minister. You have in Israel a situation today that the prime minister can really be re-elected with no limitation on the number of terms. and he's already more or less 16 years in the office. And listen, every human being, believe me, which is 16 years in office as the prime minister, something is happening there. I mean, we're talking about human beings. This is why we think that we need to restrict the term that a person can be in such a powerful position. So in Israel, we have a prime minister which controls to a great extent the government. Government controls the Knesset, and the term of the prime minister to be a prime minister is unlimited. Now, when we are going to really pass this reform, the justices in our country is going to be completely dependent on the coalition. Yes, I know in other judicial system, the president may appoint really the people to the Supreme Court. But I'm talking right now about Israel. I'm talking about the Israeli system. I'm talking about our culture, by fact, not by definition of theory, theoretical definitions. So think about the situation. The judges in Israel are completely dependent on the coalition. Appointments to the civil service can be done without really a criteria or any appraisal done by a different body. People will tell me, well, this is the case even in the United States. I mean, they can really appoint people from the party and so on and so forth. Yes. But in our country, in our political parties, when you appoint a member of your political party to any important position in the civil service, it's not exactly always a regard to qualifications. There is a pressure on the ministers from inside the party by members who are very influential in collecting votes. So you will not have any more any restriction on appointment of civil service. It's going to be done by a discretion of a minister. This is more or less what the reform is telling you. So think about the civil service this way. Think about the judiciary. Think about the fact that it's really being controlled by a prime minister who controls the government, that controls the parliament, and that's a situation we're going to get out of it. Now, I'm not saying that a certain modification is not necessary. And I'm not saying that there shouldn't be an overriding decision by the parliament to really cancel a decision of the court which decide to cancel a regular law. I think there should be a balance. There should be an ability to change this and create a better balance between the Supreme Court and the Parliament, because no basic right is absolute. Many people don't quite understand that even when you create basic rights, they are not absolute. They always can be given really a way to a very major public interest. And then this decision is there is really that weighty public interest which justifies the infringement of a basic civil right. We don't have to let it be decided only by the Supreme Court. It can be really done in a more balanced way, but I'm not getting into the details right now. But the way I'm saying again that this overall judicial reform was presented and appeared and aimed at, it will change our democracy.
Professor Bell, I would like you to respond to this allegation, mainly if the judges will be now appointed by the politicians, and if the court will lack the ability to cancel laws that the politicians enacted and won't be able to annul any act of the government because you take away reasonable clause and others, don't you shift all the power to the politicians and actually get away with balances and checks and put the politicians on top without any review?
There's something very odd about the way Royal is presenting this, and it's something that I can't quite get my head around, because on the one hand, Uriel served in the Knesset, and so when he says he's shocked to find that there's politics going on in appointments, and well, of course there is, but Uriel may not have served in other countries. Parliaments may not be aware that there's politics going on there too, but okay, all right. But then he describes the government, the prime minister, as all-powerful in Israel, in the absence of this aristocracy of the court that will serve as the...
well, he can fire ministers, and he can appoint ministers.
And this is something that simply is...
That gives a lot of power.
It's mind-boggling, if I can. Again, I did not interrupt you every time that I disagreed with you, okay? You have... Oh, yeah. You have in the UK, you have basically a system of government where the government is all powerful. The government there's basically a system of government of one chamber, the House of Commons, which controls most everything. There are some residual powers left here and there, but more or less it's the Parliament is supreme. And the government is comprised of, in almost all cases...
We have time to ask questions afterwards.
In almost all cases, the party that won the majority of seats, the Commons. Now, in Israel, that's never happened. And I don't see any time in the near future where it's likely to happen. Every single government of Israel has been a coalition government. There's never been and there's a reason for this too. That's because Israel has proportional representation in its elections, which forcibly distributes powers and amplifies the powers of minority groups. And so almost every minority group can get representation in the Knesset. And all governments are unstable. No government lasts a term. Right? The one exception was interrupted by the Yom Kippur War, but in every other case, they're toppled early, and they're toppled sometimes without the Knesset even falling. There's roughly a Knesset every 3 years, and a government more frequently than 2+ years on the average. Governments here are weak. Prime ministers have always complained that they're weak, and by the way, they're right. The one all-powerful prime minister was not all-powerful because he was prime minister. He was all-powerful because he controlled all these extra state institutions from before the state. If you look at you look at the modern prime ministers, all of them complain, rightfully so, all the time about how little they control, about how little of their agenda they can get through. If you look at this government, how much of its agenda is it going to get through? And the answer is very little. It's not possible to do so. And so you're describing an imaginary system in which there is, in the absence of the judicial aristocracy, will be run over by an all-powerful prime minister. That's simply not the way things work here. On the other hand, this all-powerful court that you want us to have because you say everybody has it, you describe that as the rule of law. I think that you simply are not being honest about what the rule of law is. There is no place in the world other than Israel where the court has the final word on everything by its own judgment, by its own rules. In other countries in the world, there is a rule of law. That means the ultimate voice is the voice of the law, not those people who pronounce themselves the exclusive oracles of the voice of the law. It means, for example, if in the United States the court issues a judgment that is disagreed with on legislation, the Congress can overturn it. If it issues a judgment on the Constitution that people disagree with, they can amend the Constitution. You can't do that here because the court simply doesn't recognize the authority of anybody to override it. Now, if I can, I just want to quote 2 sentences from Abraham Lincoln's first inaugural address. He says, "I do not forget the position assumed by some that constitutional questions are to be decided by the Supreme Court, nor do I deny that such decisions must be binding in any case upon the parties to a suit. as to the object of that suit. But while they are entitled to very high respect and consideration of other parallel cases by other departments of the government, the candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made, the people will have ceased to be their own rulers. You could choose. Do you want to have democracy or not?
Let me jump over to an issue that has to do with Shurat Hadin, which is the war crimes allegations. As we all know, the government was able to pass one of the sections of the reform, which is getting away with the reasonable clause. The court cannot cancel acts of the government based on being unreasonable. And some say, the opposing to the reform say that this put a threat on the idea of soldiers and put them in risk for war crimes allegations and investigation in the International Criminal Court because it weakens the judiciary system in Israel. Professor Bell, I would like to start with you, if you can comment about it, and then Advocate Lin.
Okay, well, this is an extremely important issue. How do we defend our soldiers from lawfare around the world? It's one that you've been very, very involved with. Therefore, you know that I've been involved with as well, to a lesser degree. I think that it's what they would call in Hebrew avodat kodesh. Right? This is one of the most important things that we can do, is make sure that the soldiers who are putting their lives in the line to defend us are defended from the enemies of the state, which includes those people who are trying to bring false charges against them in international tribunals. Now, there is not a single case that I can think of where any soldier has ever gotten off on false charges like this, because he said, but wait, Israel's Supreme Court is the only one in the world that can overturn decisions of the government on reasonableness grounds. It can fire ministers. And the court said, oh, well, okay, then go home. You're all right. No charges. That's not the way it works. There have been politically motivated charges against Israeli figures for decades. Right? Sharon had charges presented against him in Belgium for alleged war crimes in Lebanon. The case ultimately got dismissed. It got dismissed not because of the superpowers of the Israeli Supreme Court. It got dismissed because of a ruling on him enjoying immunity as an elected official, and because of political pressure that was brought to bear in Belgium to stop prosecuting these kinds of cases, political pressure brought primarily by the United States. There is no reason to think that all of a sudden, when it comes to this, that we're going to start enjoying immunity. If only we give the court superpowers, all of a sudden our soldiers will get off the hook. The proceedings in the International Criminal Court, they didn't start in 2015, as you said. The PLO has been trying to bring cases there since 2009. There's a full investigation going on right now that will result in charges, against Israelis. I can guarantee it. Okay, it's an unfortunate reality, but it's a political reality. That body is not favorably disposed to the law. It is favorably disposed to bringing charges against politically unpopular defendants, and that's us. And I can guarantee you that scotching the reform, if we make a mistake like that, will not save a single one of those soldiers. If we want to save those soldiers, we have to use the tools at our disposal, and Nitzana knows what they are, and she uses them every day, and we have to use the political pressure that we can bring to bear. And God help us if we think that, oh, well, wait, let's give our courts unique powers in the world to do anything that they want, and then our soldiers will be safe. They will not be.
Thank you.
What is the question?
Do you, well, you can agree with what Professor Bell just said. Does the taking away the reasonable clause harm the complementary principle of the court, weakens the court in the eyes of the ICC, and now it puts in risk those IDF soldiers for being investigated for war crimes allegation in The Hague?
If the overall judicial reform presented by the coalition will pass, we are going to cripple our democracy. We're going to change our democracy, not for the better. I think we are too much thinking that the Israeli court is too powerful. He is powerful. He has to be powerful, but he is not too powerful. He is modestly too much powerful. But he is powerful. He is powerful because he must be powerful. What are we talking about? Gentlemen, ladies and gentlemen, think about it. In which democracy you will have a culture, and I must repeat it, that you can appoint a person who committed crime while being a minister, appoint him as a minister. What do you think about it? Don't you understand we don't really have a real ethics and culture in our political system? Don't you understand that the fight for political power is really paramount to any other consideration? I have to give you more examples, and without any shame, after he already served as a minister, and later on being convicted of corruption by a plea bargain. Again, appointing him as a minister, changing a law to make it possible for him to be a minister. What kind of a political system is that? Think about the educational value that you pass to the young generation. I don't think we really think about this enough, because this is really a striking example why we need the power of the court in Israel. Otherwise, we are going to go down more in our ethics, in the basic of our values, which are really the real content necessary for democracy. Democracy is not only carrying an election and who won the majority is right now can do whatever he wants. Democracy is much more than that. A lot of values. We don't really, unfortunately, keep on to those ethical values. And this is why we must have this judicial power. And I'm not saying it's not exaggerated. It should be modified, but not at all eradicated. This is going to be a terrible danger to our country and our democracy.
I would like to...
Why they came so
I
lately?
told you it will be a dignified, it will be a good discussion, dignified audience. Of course, we wrote from both sides. Just last question before we go to the audience questions. I hear from what you say that you are in favor of a compromise. Am I right? Are you in favor of a compromise?
Yes, but
You have
Yes.
to microphone so you can get your applause at the end.
but not a compromise that it's really an outright concession or admitting that this proposed overhaul change is justified. It is not justified. Some modifications are, but not in such a way, and not in such a scope, and not in such tenacity.
Professor Bell, are you in favor of a compromise?
The essence of democracy is compromise. That's, I think, maybe one of the chief advantages of, I don't know, it definitely one of the chief advantages of democracy is that it forces compromise, especially in a system like a country like ours with such sharp divisions, where no one has a majority. The only way to reach anything is by compromise. The legislative process forces us to compromise, and I hope there will be a compromise at the end. That is, I hope that legislation will be passed. Now, what's making it difficult,
we can do it together,
I think.
Professor Bell, me, my colleague.
So, I think what makes it difficult at this point to reach a compromise is that too many of those people who acknowledge, as Uriel does, that the court has overstepped, the court has seized for itself too much authority, oppose judicial reform because they don't like the style, or they don't like the personnel, or they disagree about this, that, the other detail. And the truth is, nobody asked me for my opinion on each and every one of these details. If I got to write it, I would write a different proposal myself.
There you go.
Right? But the whole point of a process like this is that once we agree on the goals, we can disagree about the means for getting there until we find something that somewhat works to get us some of what we want. And instead of going out and saying that having a democratic system in this country is going to be the end of democracy, and there's no way to protect human rights in this country without giving an institution the ability to do whatever it wants, subject to no limits. And we can't have a real court system unless we allow it to eviscerate the rule of law, get rid of the law and act according to it. Now, all these things, this is crazy talk. This is the way we avoid getting to compromise. This is the way we don't get anywhere. So if you want to get to a compromise, then stop the posturing against reform on all these irrelevant grounds. Let's agree that we want one, and let's sit down and just figure out a way to do it that will satisfy most of what I want and most of what you want.
Well, thank you very much for this fascinating discussion. Now we're going to take some questions from the audience. Rachel will read us the questions. And unless it's indicated specifically who is it for, we'll just ask the both of you to answer.
I wish someone had asked some questions for Nitzana. That would be. I think she can always interject. She's the boss. Okay, like I said before, we're going to do our best. We don't have unlimited time, but we'll try to ask as many questions as we can. Okay, first question. Due to our unique situation, some jurists suggested a constitutional court in addition to our Supreme Court. Could the panelists share their views of this approach? Why don't we start with Advocate Lynn, and then we can... What do you think about adding a constitutional court?
No, I don't think it's necessary. I can tell you right now, I can foresee and predict it's going to be a terrible battle that will tear all the political parties. There will not be an agreement as to the authority of this court. There will not be an agreement who will sit in this court. We better not really get into it. I want to tell you, when I passed the basic law, human dignity and freedom, the phrasing of the Ministry of Justice was that the Supreme Court, while sitting as a constitutional court, will decide so and so. And I erased the word sitting as a constitutional court because I knew what kind of questions and problems it will arise and create.
Professor Bell?
I think there are two advantages to a constitutional court. So one of them is that constitutional issues often involve inevitably judgments that are closer to policy and closer to politics than ordinary law. And therefore, in most of the world, those parts of the world that have constitutional courts, the constitutional courts are selected also through a process that allows more public input so that there's more reflection of public will in their decisions. I think that removing those sorts of things from an ordinary court of law and putting them in one that does this sort of thing could be very helpful. I think also that because this court has taken for itself a role not only in creating constitutional law, but in constitutionalizing texts and then deconstitutionalizing them and constitutionalizing other texts and constitutionalizing principles and then unconstitutionalizing and more or less making it up as they go along. This particular court, the court we have now, the Supreme Court of Israel, has lost public confidence in matters of constitutional law, and it would be a good thing to move that somewhere else. That said, a constitutional court, like any other court, is ultimately only as legitimate as the degree it follows the rule of law, which means that if you want to have a constitutional court, it has to have clear constitutional rules that it must obey. Right? If you simply create a new court that does whatever it wants without a written constitution and makes up rules as it goes, we will just move the crisis somewhere else.
Okay, thank you. All right, next question. There has been a lot of talk lately about checks and balances. The court's check on the executive and legislation are clear, but what are the checks against the court? So we'll start with Professor Bell. Professor Bell, currently, what checks are there on the court, and then what checks do you think there will be on the court if the reform is passed?
That's an easy question. Under the current system, as created by Aaron Brod, what are the checks on the powers of the court? None. Is that a healthy situation? No.
Advocate Lynn, what are the checks on the court under the current system?
Well, first of all, the court has to pass decisions according to the law. And it should not pass decisions against the law. And then he should fulfill his functions when there is a very defined function that he has to fulfill. Like, for example, I will take an example, the United States system. If the court decides that a certain act or legislation is non-constitutional, you decide to repeal this action or decide to repeal this law. That's the checks that should be exerted by the courts.
Okay. Go ahead.
Sorry if I misunderstood. I'm going to correct myself. No problem. What again? Oh, I said that the restraint of the court should be the phrasing of the law and the intent of the law. What do you mean with law? Whatever the law is presented to him. I mean, the courts are not sitting on cases where there is no relation to a law. There is no case that the court's supposed to decide when a law is not involved. Well, the restraint is they should judge by the law. And sometimes he needs to have some interpretation. When the interpretation is necessary, he should really judge that by the values that are more or less accepted in our country.
Okay. We're going to keep going.
Yeah.
We're going to keep going.
Next question.
Yeah. All right. So one of our participants wrote that she's usually an optimist, but on the topic of the possible upcoming ruling of the Israeli Supreme Court, it feels like a vicious cycle. The court can say that they are overturning what the legislation did, and the legislation can come back with another law. So how do we stop this sort of vicious cycle based on what's happening right now? We can start with Advocate Lynn.
I'm going to refer to a very specific dilemma here. And the specific dilemma is the case where the Supreme Court decides that a regular law is not constitutional, or that a regular law is infringing the basic rights of the individual, not according to the criteria spelled out in the basic law. And I'm not going too much into detail. Now, in this case, as I proposed, the parliament, the Knesset, can decide to override this decision of the court, but not with a simple majority, but a special majority. I'm not saying not by a simple majority, because a coalition majority is very automatic and it's very obedient. And it should be a special majority to be sure that really the right consideration was put into this specific case. So this is how the vicious circle of canceling here or canceling that should be solved. I'm saying that I'm willing to see a situation that the Knesset is overriding a decision of the Supreme Court, repealing an ordinary law. And as I explained before, no basic law of the individual is absolute. In any legal system, we know if there is a weighty public interest or a weighty national interest, then a basic right of the individual must give way. But deciding if there is this weighty interest should not be done only by the Supreme Court. If the Supreme Court decided there is, it's okay, but then the Knesset should have the right to override this decision with a special majority.
Professor Bell?
To understand the vicious cycles, let's go to a different example, okay? The Supreme Court has waged a multi-decade war to overturn this practice that was instituted back in the days of Ben Gurion of more or less exempting Haredi yeshiva students from the draft. And so it was done by executive decision, and they struck that down. That was done by regulation, and the court struck that down. There was legislation, and the court struck that down. There was then a big compromise and more legislation. The court struck that down. Now, the Haredi parties, in order to try to get this past the court, have suggested, well, let's make a basic law Torah study that will really make it so the court won't strike it down. But of course, that's not so, because the problem here is not cycle. It's not this enacts and that one acts. The problem here is that the court fundamentally does not accept the rule of law. The court fundamentally believes that the values that it favors are superior, and those ultimately are what must decide everything. And that leaves us in a position where the dilemma of today, and let me give it, what's the dilemma of today? We have a group. How large this group is, we can argue, but whatever. There's a group of people like me who believe that the court has seized untenable powers in democracy and has eviscerated the rule of law. That some reform is necessary, and Oriel and I can disagree about which and how much, but some reform. But the court is now on the verge of announcing, no, you can't do that. Reform is illegal, right? If you pass a law, it doesn't count unless we say so, unless we like it. Now, where does that leave people like me who believe in a rule of law? Right? Now, I think that because I believe in democracy and because I believe in the rule of law, I ultimately think that I would not prefer to go beyond simply enacting a new law or creating a new institution or altering the way by which we impanel this institution. But if the court is really determined to go on this course, then there is no escape. There is no escape because at some point, some of the people who are trying to act according to the rules and are getting stepped upon are going to do the kinds of things that should not be done in a society. And I don't want to get to that point. So I'm begging them, please, to exercise just the slightest bit of responsibility and to go off this course. There is a reason why the rule of law is essential to society, and it's pure arrogance to think that the rule of law is identical to the rule of these individual people. It's not.
Next question.
There are actually some questions, and I'm going to try to combine them, relating to the appointment of judges and also the removal of, let's say, justices, because we're talking about the Supreme Court. In the United States, for example, there are, Supreme Court justices are appointed. They can be removed. Actually, I'm not even sure how that would be. Somebody wrote that. I'm not even sure how you could remove a Supreme Court justice. But anyway.
There is a process.
There is a process. I don't know if it's ever happened. Okay. In any event, the question is relating to the process right now. If there's some sort of consensus that there does need to be some sort of reform, is there any mechanism to reform in some way the makeup of the court? Either by appointment or removal. And if there is really somebody that's seen as truly corrupt, what can be done then? Let's start with Professor Bell this time.
For removing justices?
What can be done at this point if there's one of the core issues of this reform is how the judges are appointed. Well, they're there. So what's the practical hope in terms of making a change in the makeup of the court?
Look, I think that we will not have a legal system if we don't respect judicial independence. Judicial independence is as important as the rule of law. And judicial independence around the world is generally understood as protecting the judges from removal for their decisions. So, as much as their decisions bother me, I think it would be terrible to put on the table the ability to remove them from the court for their bad decisions. I think that that's something we have to live with if we want an independent judiciary.
Okay, Advocate Lynn, I'm guessing you agree with that.
I will refer to appointment of the judges. Listen, many people point out to a method applied in other countries, like, for example, in the United States, Supreme Court judges are appointed by the president, right?
With the ratification of the Senate.
Not right?
Yeah, appointed by the president with the ratification of the Senate.
All right. Exactly as Professor Bell said right now. He's correcting me, and I agree to his correction. Now, we all must understand that we have to look really into the nature and culture of our actual political system. Sometimes we make a mistake because we really ignore the working and the culture of our political system. If here in Israel, the coalition will have the full power to appoint the judges, this, to my appreciation, is going to be a very bad move, in spite of the fact that they are a coalition. because the appointment, as Professor Bell right now pointed out, is for a lifetime. An appointment of a lifetime, sometimes coming from a coalition with a very certain and sometimes even extreme point of view, could be unbalanced. And the dependency of justices on the decision of the coalition only will create here in Israel judges that are trying all the time to please the government. They will not really be independent in their decision. And the public would lose a lot of confidence in the judicial system. Because we know very well in the mind here that whenever the coalition appoints judges, it's done specifically to achieve a certain specific purpose. So I don't really believe that giving a full power to the coalition is necessary. I believe the coalition should have quite a weighty power in deciding that, but not an absolute power.
I think Professor Bell wants one response on the issue of appointment.
Yeah, just very briefly. So first of all, let's understand we don't have, the system we have now, we've not had since the beginning of the state. The first judges were appointed to the Supreme Court under the rules then, which were appointed by the Prime Minister, approval by the Knesset. We had some terrific judges then, in particular Agranat, who's one of the most famous civil libertarian judges on the Israeli Supreme Court, was appointed in that fashion. I don't think that anybody ever doubted his independence. And I'll say that in the reverse system that we have now, where it's not simply that it's appointed by a committee that's dominated by the judges, but where the judges are quite vocal about using the power they have in the appointments committee to veto any judges that don't share their aggrandizing view of the power of the court. We have a different sort of judge, and so there are some cases where it's broken out in the open, where the judges have vetoed the appointments of people because they didn't share the activist agenda of the president of the court. And so, for example, Justice Barak, then President Barak, vetoed the candidacy of Professor Gabizon, who was a brilliant woman, who would have been a terrific justice. And it's, I think, awful, the loss of the court, the loss of all of us, that she never got to serve because of the political agenda of the Chief Justice of the Supreme Court. Any appointment system is vulnerable, but it is, if you look at the court now, I think that it's very hard for me to accept the idea that these are inferior judges to the judges, let's say, in the US Supreme Court, which is chosen a different way, or that they are superior to the judges that would be chosen if there were a process with less of a throttle by the president of the Supreme Court. I think we could get better judges if there were more public debate and more openness to the idea that there are different possible ways of conceiving of the judicial role.
Thank you so much, both of you, for sharing your views with us. I'd ask everybody to stay just a few more minutes before we conclude, but we would welcome you to feel free to exit the stage or to stay seated, whichever you prefer. My personal takeaway from this is that there is a chance for compromise, and that's what I'm going to go home with tonight. Okay, so let me just first of all thank everybody so much for coming. I just want to share with you very quickly a few Shurat Hadin events that we have coming up that I think could be of interest to you or to friends and family in the States and Canada and the UK, anywhere in the world. First of all, we have a lawyers and activists seminar. We haven't had one since 2019. Unfortunately, it was halted because of COVID, but was one of our most popular trips, seminars in Israel. We give full CLE credit for all the lawyers, and it's really an incredible experience in Israel to learn about the law, while you can also learn about issues facing Israel today. We also have a mission, a Mossad mission. Nitzana mentioned it. We've had thousands of people attend. I think we have a very quick video. Do we have a quick video, or? Just so you can see how incredible it is, truly just a minute. But I think this could be something that could really be of interest to your friends and family. Please take a look for a moment.
All eyes, and she's like, oh, I don't know, I guess I could give you a little.
That wasn't it.
The ultimate Mossad mission. Imagine meeting Mossad agents and top dignitaries. Imagine entering a Hezbollah tunnel.
Imagine watching the trial of a Hamas terrorist.
Now, stop imagining. This exclusive program will give you unparalleled access to the fragile security reality of Israel, the threats and challenges facing Israel, and the methods Israel uses to counter terrorism while maintaining its democratic values. It's time to see how Israel defends its borders with your own eyes. Meet the heroes who work behind the scenes. Observe the various difficulties challenging the Israeli security systems and the way they overcome them. Hear lectures by former and present senior-level personnel of the IDF, the Israeli Security Agency, and the political system. Get the chance to ask them your burning questions. The full story of Israel, a democracy surrounded by terror threats.
Join the ultimate Mossad mission.
So the next mission is going to be in May. And of course, we welcome you to ask us any questions you have. Everybody should have received a pamphlet. On the back is all of our contact information. Please be in touch with us by email, by phone. We are here to help you to answer your questions. Also, I have to just propose to you that inside the pamphlet is also a pledge card and an envelope. As you know, Shurat Hadin is a nonprofit organization. We are 100% supported by private donors all around the world who we love and appreciate, many of whom are in this room. And we thank those of you who support us. As Nitzana mentioned, we right now have a very, very critical pressing project with the driving course. We've already lost over 30 people in Israel just in this past year in terror attacks involving vehicles. This has become the newest weapon. We all lived through the knife intifada, and we lived through the second intifada, where the weapon of choice was suicide vests. This time it's cars. They're shooting at our cars. And it's not just in Judea and Samaria, it's all over the country. We have thousands of people interested. We are doing this free of charge. And unless we raise the money to support this project, we won't be able to continue to train and to save lives. We have a project, a campaign going on online. We're actually pretty close to our goal. If everybody donated in this room $180, we would reach it, and we'd be able to train 1,500 people. I think that is unfortunately not even going to be the tip of the iceberg based on the response that we're getting to this project. But in your pamphlet is an envelope with a pledge card. It explains how you can donate, how you can get tax receipts from the US, the UK, Australia, and Canada. Credit card donations can be made through our website. And if you'd like to leave an envelope here with us, you can. We would be happy to accept it, of course, any one of our staff, or feel free, of course, to mail it. The envelope that you were given is to our Israel office. If you're in Israel, please mail it from Israel. If you're outside of Israel, please don't mail it to our Israel office. It may never get to us. There is an address where to mail it in the United States, in Canada, in the UK, in Australia. And again, please reach out to us if you have any questions. Rachel@israellawcenter.org. I am here to help you with anything you need. And I just want to thank you again so much for attending tonight, this really important debate, and to thank our debaters again, and Nitzana, of course, for hosting all of us. Thank you so much. And good night, safe travels, and Chag Sameach.
יופי, יופי.